Good morning. Could you please stand for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Good morning, everyone. I want to welcome you to the May 22nd, 2023 Land Use Hearing Officer hearing. My name is Susan Finch, and I'll be presiding as the hearing officer over today's cases. Let me start by introducing Mr. Tom Hisney. He's with the Development Services Department, who will introduce other staff members and go over any changes we have to today's agenda. Mr. Hisney.
Good morning, Madam Hearing Master. My name is Tom Hisney. I'm Executive Planner with the Development Services Department. To my right is Carmen Mason. She's the hearing technician. She's with Development Services. To my left, we have Cameron Clark of the County Attorney's Office. We'll also be joined a little later in a meeting by Mary Dorman of the County Attorney's Office. Throughout the course of the hearing, a number of planners with the Development Services Department will be introduced to present findings and or recommendations on the various cases, and they'll be introduced individually at that time. Right now, I'm going to read in the published withdrawals and continuances for today's hearing. Item A1, Special Use 22-1657. The applicant is Todd Scime. This application is out of order to be heard and is being continued to the June 26, 2023 Land Use Hearing Officer meeting. Item A2, Variance Application 23-0005. The applicant is Jon Grisar. This application is out of order to be heard and is being continued to the June 26, 2023 Land Use Hearing Officer meeting. Item A3, Variance Application 23-0142. The applicant is Mark Bentley. This application is out of order to be heard and is being continued to the June 26, 2023 Land Use Hearing Officer meeting. Item A4, Special Use Application 23-0144. The applicant is APC Towers 4 LLC. This application is out of order to be heard and is being continued to the June 26, 2023 Land Use Hearing Officer meeting. Item A5, Variance Application 23-0182. The applicant is Bert Thomas. This application has been withdrawn by the petitioner. Item A6, Special Use Application 23-0219. The applicant is Dean and Sonia Slaven. This application is out of order to be heard and is being continued to the June 26, 2023 Land Use Hearing Officer meeting. Item A7, Special Use Application 23-0227. The applicant is Phoenix Waters. This application is out of order to be heard and is being continued to the June 26, 2023 Land Use Hearing Officer meeting. And finally, item A8, Variance Application 23-0333. The applicant is Daniel and LaCretia Spivey. This application is out of order to be heard and is being continued to the June 26, 2023 Land Use Hearing Officer meeting.
Thank you, Mr. Hisney. I appreciate it. Let me start by going over our procedures for today's hearing. Our hearing today consists of agenda items that require a public hearing by a land use hearing officer. I'll conduct a hearing on each agenda item and will file a decision within 15 business days following today's hearing. Our hearing is informal. I'll ask questions related to the scope of direct testimony. I may call and question witnesses as I deem appropriate, and all questions of procedure, and we'll decide all questions of procedure. I'll take evidence, but will exclude evidence that is irrelevant, immaterial, or unduly repetitious. Evidence may be presented in written form, and all testimony must be under oath. Hearsay evidence may be used to supplement or explain other evidence, but shall not be sufficient alone to support a finding by me unless it would be admissible over objections in a civil action. Our order of presentation today is as follows. You'll note on the agenda we have the first part of the hearing are variances, and then the latter part of the hearing are special uses. The order of presentation for those two types of cases are the same except for who starts. So in the cases of variances, the development services staff person that was assigned, the planner that was assigned to the case goes first. In the case of special uses, the applicant goes first. So that's the difference. But other than that, so development services on variance has 5 minutes to present their findings. Then we'll go to the applicant. The applicant has 15 minutes to make their presentation regarding their request. Next up would be proponents, anyone who wants to speak in favor of an application. Total proponent testimony time is 15 minutes. Next up is opponents, anyone who wants to speak against an application. Also 15 minutes for everyone total. We'll then go back to the Development Services Department, who has 5 minutes to address any issues, comments that may have arisen during the hearing. And then finally, the applicant gets the last word. The applicant has 5 minutes for rebuttal. Regarding that time, that 15-minute time frame for proponents or opponents, we have some cases, I understand, that have some people that want to speak either side, and that's terrific, and we appreciate your participation in the process. So 15 minutes total. What will happen is I will ask for a show of hands of how many people want to speak in the room. We also have people that are participating virtually online. So we'll get a show of hands of how many people want to speak, and we will have that 15 minutes divided as equally as we can. If you want to, sometimes a more efficient use of time is to designate a spokesperson, one person that can take the bulk of that time, and then everybody else can come and put their name and address on the record if they'd like to be a part of that record. Now, when you come up to, if you're in the podium, if you're in the room or online, come up and give us your name and address before you start your comments. We are recording this hearing, and we want to make sure that we have your name and address for the particular case you're speaking to correct. If you are in the room and you're done speaking, if you could see Allison, she's at the end of the dais, she's with the clerk's office, and she has a log that we keep track of who speaks and to what case number. So when you're done, just step over to her and sign in with your information. I would really appreciate it. All right, so then with that, let's go to the county attorney, who will provide the legal requirements for appealing a decision made by a land use hearing officer. Mr. Clark.
Thank you, Ms. Finch. Good morning, everyone. My name is Cameron Clark. I'm an assistant county attorney. This land use hearing officer public hearing is for variance and special use requests. This is the time for interested parties to present evidence and testimony. Once the hearing officer has closed a case, the record of that case is also closed, and no new evidence regarding that case may be submitted thereafter. Any decision by the hearing officer may be appealed to the Land Use Appeals Board. Should a decision of the hearing officer be appealed, the evidence and testimony presented at this public hearing shall be the only evidence that is subject to review by the Appeals Board. In reaching a final decision on petitions, the Appeals Board will only consider the decision of the hearing officer and the record that is made at this public hearing. If an appeal is filed, the Appeals Board hearing shall consist of oral argument by the party appealing the decision, by county staff, and by any interveners, each of whom may be represented by legal counsel. The following shall stand to appeal a decision of the hearing officer or to intervene in an appeal. First is the applicant. The second is anyone who appeared before the hearing officer, presented testimony or other evidence, and is adversely affected by the decision of the hearing officer. It is the role of the county attorney's office to ensure that no new evidence or testimony is allowed before the appeals board that was not presented to the hearing officer at today's hearing. The county attorney will recommend the appeals board disregard evidence or testimony that is outside the record made at today's public hearing. Any evidence presented to the appeals board that is outside today's record could jeopardize the legality of the appeals board decision, and the presenter of that evidence could hurt their own cause. The safest course of action, then, is for you to write down any comments that you make today and to repeat those comments to the appeals board. Thank you.
Thank you, Mr. Clark. I appreciate it. As I mentioned, all testimony must be under oath. So if you are in the room or online and you plan to testify, if you could please stand, raise your right hand, and I'll swear you in. Do you solemnly swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth? Thank you so much. Please be seated. All right, then with that, Mr. Hisney, we're ready for the first case.
All right, so on today's agenda, we have no vested rights cases, no fee waiver requests, no remands, and no reconsideration requests. which then takes us to Section F of the agenda, which are site development variance requests. First case is item F1, variance 23-0164. The applicant is Lee Ann Law. They're requesting a variance to encroach into a required wetland setback. Staff findings will be presented by Carla Shelton.
All right, thank you. As I mentioned, variances, the staff person goes first. Good morning, Ms. Shelton.
Good morning. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on April 25th, 2023, is to allow for the placement of a fence within the 30-foot wetland conservation area setback. Per LDC section 4.01.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests the placement of a 4-foot tall aluminum fence within the 30-foot wetland conservation area setback. The applicant requests a 25-foot encroachment into the setback to allow for a remaining setback of 5 feet.
That concludes your presentation?
Yes.
All right, thank you so much. Is the applicant here? Go ahead and come forward. Good morning.
Good morning, how are you?
I'm good, thank you. Give us your name and address to start.
My name is Lee Ann Law, and I live at 12427 Prairie Valley Lane in Riverview. It's in the Triple Creek community.
Okay, you tell us about the reason for the variance request.
Yes, I can. Our property abuts the Boggy Creek Preserve, which is actually very nice and very private. We sustained tremendous feral hog damage last year to the extent that almost the entire wetland setback was destroyed. We filled it all in, put sod back in, and then again this year, again in January, we sustained some more. So now it looks like a battlefield back there. And the only way that we can control this, other than having the hogs trapped, doesn't preclude them from coming back. They think that's their picnic area, I think, because we've sustained the most damage in the community. So we see no other alternative but to try and erect a fence to try and keep them off the property and keep the wetland setback the way it should be.
Okay, I've looked at the backup and I see all the pictures that you submitted. So it's the area outside your pool cage.
That's correct.
That's all dug up, that's what they've done?
Yeah.
All right, and then in your narrative, it said that you have suffered, that your neighbors haven't suffered equally, but it looks like your neighbor to the west has a fence.
Yes, he does.
And you don't have one outside of that pool cage area?
No, I do not.
I understand. Okay.
Because I can't, because of the wetland setback, I would have had to obtain a variance.
I understand. And you've talked to your neighbor about the variance request?
Yes, I did.
Okay, and they don't have any problem with it?
No, they do not.
All
As a
right.
matter of fact, they don't live there anymore. They just sold their property.
Ah, okay. All right. Thank you for your testimony. I appreciate it. If you
Thank
could
you.
please sign in at the clerk's office. All right. At this time, we'll call for anyone who would like to speak in support. Anyone in favor that would like to speak? Seeing no one, anyone in opposition to this request, either in the room or online? No one. County staff, anything else, Mr. Hisnay? Ms. Shelton, anything else?
No, ma'am.
All right, ma'am, you have the last word if you'd like it, but you don't have to take it. All right, thank you for that. I appreciate it. So we'll close variance 23-0164 and go to the next case.
Next case is item F2, variance application 23-0304. The applicant is Wayne and Rosemary Curtis. They're requesting two variances, one to encroach into the required wetland setback and another variance to lot development standards. Staff findings will be presented by Carla Shelton.
Good morning.
Good morning. The applicant is requesting setback variances to accommodate a proposed single-family dwelling on property zoned ASC1. The first variance for wetland setback, per Land Development Code Section 4.01.07 30.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a required 30-foot wetland conservation area setback. The applicant requests construction of a portion of a single-family residence within the 30-foot wetland conservation area setback. The applicant requests a 25-foot encroachment into the setback to allow for a remaining setback of 5 feet. The front yard setback, per Land Development Code Section 6.01.01, the required minimum front yard setback for property zoned ASC1 is 50 feet. The applicant requests a 25-foot reduction to the front yard setback to allow a front setback of 25 feet from the east property line. Staff findings. The subject parcel is zoned ASC1, which requires a minimum lot size of 1 acre, 1/5 of which may consist of conservation or preservation areas that receive density credits under the comprehensive plan. The parcel is approximately 2.21 acres in size, but comprised largely of submerged lands in Brant Lake that do not receive density credits under the plan. The non-submerged area is less than 1 acre in size. Therefore, the parcel does not meet the minimum lot size required in the ASC1 district. Additionally, the parcel is served by a septic tank and located in a wellhead resource protection area, Zone 1, and does not meet the minimum lot size of 1 acre of upland required for a septic tank in the wetland, in the wellhead resource protection area, Zone 1. However, the parcel has been certified as a legal non-conforming lot per NCL 22-0676 that has been placed in the case record. Finding number 2, a wetland setback compensation planting plan has been provided on the site plan submitted on March 21st, 2023 that provides equivalent square footage of compensation planting to the amount of encroachment. That concludes the staff report.
Just one quick question before you go. I noticed from the backup that the property owner bought the property, it appears in 2007. Do you know if the 30-foot wetland conservation area setback was in place at that time?
We'll take a look at the site plan.
Thank you.
I don't have all of the file back up here with me. If this is a platted parcel, and it was platted at that time, then yes, it would have been, the 30-foot setback would have been on the plat. If it is not a platted parcel, then it would have required a wetland line delineation by EPC, so whatever that was done.
But because it is platted, then you're saying it was a requirement at the time in 2007?
Yes.
Okay, that's all I needed. Thank you so much, I appreciate it. All right, is the applicant here? Good morning.
Good morning. My name is Jesus Murley. I am at 12506 Bronco Drive, Tampa, Florida. I am the civil engineer representing Rosemary and Wayne Curtis with 5M Civil LLC. To go back, we do have 2 variances, and this is as Carla said, a non-conforming lot of record with a substantial amount of submerged lands. And the reason why we need both variances is to work together because the wetland setback is on the rear, as you saw, Madam Hearing Officer, and the front setback, obviously in the front. And when you squeeze them together, a 50-foot in the front and a 30-foot in the back leaves a tremendously small sliver of land available for development, which really makes the lot undevelopable. So if you look at the site plan, the architect and the owner has been very creative in trying to squeeze this thing in between a 25-foot front yard setback, which appears consistent with the neighbor across the street, which they also appear to have a reduced setback from the 50-foot. And The 5-foot setback in the rear really is applicable to the porch. That's like the maximum encroachment into the wetland setback. We were trying our best to keep 15 feet, and we did so for a significant portion of the site, as you can see on the site plan. Again, I just want to emphasize that if we had the 50-foot setback and the 30-foot rear wetland setback, this sliver of land would maybe you fit a 200-square-foot home. I mean, that's about it. It's significant hardship to have both of these setback requirements.
Oh, is that the end of your presentation?
It is.
Cool. All right.
I can take any questions.
I do. Yeah, thank you. So first, how many square feet is the proposed house? I have your site plan in front of me, and the scale is such that it's hard for me to tell. What is the square footage?
I apologize. I think it's I want to say it's the bottom story. I'll say the footprint.
The footprint is fine.
About 2,500 square feet.
Okay, and then it's 2-story?
It will be, yes.
And is the second story is something less than 2,500 square feet?
I don't think we've gone that far into architectural design yet.
So would it be fair to say that the maximum it could be, in your estimation, I'm not holding you to it, would be 5,000 square feet for the house?
Yes.
All right. Okay, the property owners bought the property, as you heard me ask. It looks from the deed in 2007, and the staff testified that that wetland setback was in place. The ASC 1 zoning setback has always had a front yard, to my recollection, staff can confirm, of 50 feet.
Yes.
So the most obvious question is, were they aware of that when they bought the property?
Oh, I'm not the owner, I don't know, but I could say the EPC approved wetland survey that they signed off on was after 2007, I believe so. So that wetland setback, or the EPC doesn't approve the line unless you build it, right? And it's only good for 5 years. So I want to say that if they had the wetland line approved, I think 2 years ago, something like that. So it was after their date of purchase. Does that answer part of your question? I know I can't answer for the client.
I think so. Is the property owner here?
Yes, she is.
Okay. So we'll ask them in a minute
Okay.
what their understanding was when they bought the property.
Sure.
Let me see. That dimension you mentioned in your presentation, if they were to adhere to the 30 feet in the rear and the 50 foot in the front, what is that dimension that's left as buildable area, approximately?
Can I show on the screen?
Absolutely.
Okay. It's not quite, I'm not sure if it's focused well enough, but this distance from here to here is 25 feet. So if we doubled that, and I'm just going to sketch on here. That's roughly the 50-foot setback.
Right.
So, and this is the 30-foot setback here.
Correct.
So this little sliver of land,
I see.
I mean, it's so small, but it's basically undevelopable if you have both setbacks in place. It'd be.
All right. Thank you. And then I noticed that they are proposing to use a septic tank.
Yeah, this is outside of the urban service area, if I recall.
And do they need a variance? I understand that the lot, because it's less than an acre, doesn't meet the minimum upland acreage by the county standards for the septic tank.
That's
but
right.
You also are going to have to get a permit from the health department for that septic tank. Is there
Yes, ma'am.
requirements that need to be varied from those regulations?
Well, I guess there's two ways to answer that question. Yes, there are mitigating measures towards getting those. I've acquired or engaged a septic tank contractor to do an advanced treatment system to mitigate for its proximity to an adjacent neighbor. I've engaged with the well contractor to put a liner in a pond to mitigate for potable well setback, which might be another question you might have had.
75-foot setback from the adjacent well, yes.
Yes, and from ponds and wetlands, which obviously will have a wetland right nearby here, so there might be something that needs to be done to the well. But I mean, in summary, really, we got to get this step done first. You know, step one, get approval to build our 2,500 square foot before we even get to what I consider step 20. If we can't get approval to build on the property, there really isn't no opportunity to, or not even a need to consider potable and septic service.
All right, and I think down to my list of questions.
Yes.
Oh, and the lot has been vacant since they purchased it in 2007?
Yes, I believe so.
All right, and so now it's the time that they would like to build. Maybe it's time to bring them up and just
Yeah.
ask them what their understanding was at the
Sure.
the date of purchase. Good morning.
Good morning.
Give us
I'm
your name and
Rosemary
address.
Curtis, 330 Inner Harbor Circle, Tampa, Florida, and I'm the owner of the property.
Thank you, I
I
appreciate
haven't
it.
been sworn in. I don't know if that matters.
No, it does matter.
Okay.
If there's you and anybody else in the room that has not been sworn in that plans to testify on this hearing or anything else on the agenda, if you could please stand and raise your right hand. Do you solemnly swear that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you so much. All right, so you heard my question about what was your understanding of the requirements regarding the wetland setback and the front yard setback when you bought the property?
Yes, when we bought the property, we bought it with a larger parcel that was attached to it. And this one was sold to us as a separate parcel as it exists, the way it exists today. We lived on the adjacent parcel
To the north or to the south?
to the north.
Oh, I see. And so that has a significant wetland and house. It's a much larger piece of property.
Correct.
All right.
Correct. And this parcel came with it.
Okay.
When we bought the two parcels together. So we just held on to this since the time that we purchased it. So, and we hadn't intended to do anything with it, but then we're hoping that we can work with, your guidelines to be able to spend some time there, still go back there because we don't live in the neighborhood anymore. So we're hoping to be able to have a home on the property.
So when you own the parcel to the north, just so I understand, the subject property we're talking about right now, it's always been two separate pieces of property?
Correct.
Correct. And so when you moved, you sold the northern parcel, the larger piece with the house, and retained ownership of this piece?
Correct.
I understand.
And it's a legal we went through the process of establishing that it's a legal non-conforming lot, and it was platted back in, I don't know if I'm muddying the water, but it was platted back in 1982 or something. I have old paperwork from the property that goes way back.
I see. Okay.
So it's not a hardship of our making.
Understood. All right, thank you. Is there anything else you want to add before I move on?
No. I did want to mention the house, perhaps with the porch, it might be 2,500, but we're not going to be getting anywhere near a 5,000 square foot house.
But there will be a second story?
We do hope to put 2 bedrooms on the second floor.
All right. Do you have any estimation what would be fair to say the total square footage?
Because the guidelines require, if we do this, the guidelines require that we make it compatible with the neighborhood. So that would keep us in like the 3,300 square foot range.
Okay, perfect. All right, thank you for that clarification. I appreciate it. If you could please sign in with the clerk's office.
Okay.
Thank you so much. All right, now we'll go to people that want to testify in support. Is there anyone that would like to speak in support of this variance application, in the room or online? Seeing no one, is there anyone who would like to speak in opposition? Okay, so let's count hands. So I see 3 hands in the room, right? Is there anyone online that would like to speak? Do we have anybody online?
I don't believe we have anyone online.
Okay, so 15 minutes. We'll give you 5 minutes apiece. If you go ahead and come forward and line up, and whoever would like to go first. Allison, you get us 5 minutes apiece. Yes, thank you so much. Good morning, sir.
Hi, I'm Charles Michaels.
Could you bring the microphone just a little toward you? Perfect.
I'm Charles Michaels,
Thank you.
17514 Estes Road. We're next door.
Are you
this
to the
property.
north?
To the south.
You're to the south. Okay, go ahead.
And that property, back when it was platted in 1982, was originally all wetlands. And there's a retention pond south of there, and they took the dirt out of the retention pond and just filled it in until they were stopped by the EPC. So that was originally never supposed to be they were trying to make another lakefront lot. And I've got some real concerns, obviously, about my well. It's got to be 75 feet from any kind of septic system. That's a real concern for me, as is the 5-foot setback from the back. Now, I understand that there's some planting that can be done, et cetera. I don't know how you make up 25 feet with plants. You know, that's a real issue with me. What we've got is a 50-foot setback, a 50-foot setback, a 50-foot setback, and a 2-story 25 feet from the, that's not compatible with the rest of the neighborhood at all. I didn't know it was going to be 2-story. The one across the street is back a little over 30 feet, but it was built in 1947. That's an old cracker house. You know, we have the Lake Brant Lake Association, which is seen as one of the best run in the area, and the whole community is contributed. We have a special taxing district, and we have contributed to keeping the lake pristine. And it's considered one of the best run lakes in the area. And I can't see where a 5-foot setback, I mean, the original 30-foot setback was there for a purpose. And I don't see a 5-foot setback not leading to some kind of degradation or pollution of the wetlands, which leads right into the lake. Thank you.
Thank you, I appreciate it. If you could please sign in. Next, please. Good morning.
Morning. My name is Ross Simmons. I live at 503 Warren Road in Lutz. Whoops. I also live diagonally across the lake from the lot in question. My wife, son, and I moved to our home in 2021, and one of the most appealing aspects that ultimately convinced us to move to the patch of wetlands, that ultimately convinced us to move there is the patch of wetlands in direct sight of our home, yard, and dock. We purchased our home with the understanding these are protected wetlands with no buildable lots being part of the land. We greatly value and appreciate this piece of nature, and to hear there's a possibility of variances being granted resulting in a home being built on these wetlands is troubling for many reasons, both as directly impacted homeowners and as a family that values and respects Florida's wildlife. Building a home in these wetlands, as is proposed, will undoubtedly result in severe displacement of our much valued and respected wildlife currently calling these wetlands home. We're fortunate enough to have an abundance of wildlife on Lake Brant, and most of that wildlife forages or lives in this patch of wetlands. We have deer, hawks, osprey, swallow-tailed kites, bald eagles, a variety of ducks, ibis, limpkins, and hingas, and many other species of smaller birds that find refuge in this land. We also have otters, alligators, frogs, turtles, and snakes that are vital to the Florida ecosystem calling this space home. To grant variances putting in jeopardy the breeding ground, source of food, and place of refuge for these very important parts of our ecosystem is not only doing a disservice to the members of this environment, but also to the community members that value them as fellow residents of the lake. This land was never intended to be built on for these very reasons. Let's please keep that in mind while considering this application. The applicant sent a note to the community members asking for our support of their variance application. In the letter, they mentioned they will build a home compatible with their lot and will respect the beauty and serenity of their setting. I find a couple issues with these statements. First, needing these variances to build a home is a direct contradiction of building a home compatible with the lot. Simply put, if they were building a home compatible with the lot, they would not need these variances. Additionally, the previous home the applicants built is the second largest home on Lake Brant, coming in at 7,200 square feet. This is more than twice the size of the average home on the lake. The applicants have already shown an appetite for large homes and have played a direct role in displacing wildlife on the lake. I have to ask myself, what has changed? What has changed that will give us confidence it won't happen again? I fear history will repeat itself and our much valued wildlife will take a backseat to their desires. The applicants have developed enough of this lake. Please don't let them develop our last piece of wetlands. In closing, I can't help but feel this is a very tactical attempt to turn a piece of wetlands into a massive financial gain, something we have seen in Florida far too many times. Lutz and in particular, the Lake Brant community values our wildlife and stands against these variances. The community is doing its part to fight the development of these precious wetlands, and we ask that you join us in standing up for all residents of this beautiful lake community. Let's stand by the original designation of this land, hold the applicants to the same restrictions every other member of our community is held to, and leave this land as a sanctuary for wildlife, something that is dwindling in Florida, in the Lutz area in particular. Thank you for your time.
Thank you so much. If you could please sign in. Next, please. Good morning.
Morning. Morning, members of the board. For the record, my name is Dan Romsberg, and I reside at 1816 Rebecca Road. I am here as president of the Lake Branch Special Dependent District, representing 98 households. We are vehemently opposed to this special request to allow building on a legal non-conforming lot on Lake Branch. Specifically, the reduction of the front yard setback is not consistent with the homes on Lake Branch and the 3 adjacent homes with a 50-foot setback. The EPC line was established along the line of the lot where it was backfilled previously and now has created a 4-foot head wall. The reduction of the EPC clear zone is not consistent with the other homes on the lake that all comply with the setback standards. Additionally, it does not meet the 50-foot backyard setback as required by the ASC-1 zoning. The lot will not accommodate the proper installation of a tank and drain field. The adjacent home due south has a potable well within a few feet of the property line, not allowing the installation of a septic tank and drain field, meeting the setback requirements. This drain field would ultimately leach into the most environmentally sensitive cypress head, negatively affecting the water quality of Lake Branch. Lake Branch is not your typical lake due to the added density of canal residences, effectively doubling our environmental impact. Our district has maintained water quality samples on Lake Branch for the last 30 years with the University of Florida and spent over $100,000 maintaining it. We do not want this pristine environment to change due to the negligence of the county allowing this lot to be built on, affecting the environmental and recreational use of our lake. Thank you.
Thank you, sir. I appreciate it. You can please sign in. All right. Anyone else before I move on that would like to speak in opposition? All right. Seeing no one. County staff. Ms. Shelton, anything else?
Yes, I did just want to point out that although a septic drain field is not shown on the plan that was submitted, if the drain field were to encroach into the 30-foot setback, it would also need a variance for encroachment.
Madam Hearmaster, I'm sorry to interrupt. We actually have another party in the audience who wishes to hand in emails and letters of opposition into the record.
Oh, of course, Ms. Shelton.
Sorry about that.
Yeah, no problem. Ms. Shelton, just hold that thought 1 second. Sir, if you want to come forward, just give us your name, and address, and then you can submit whatever documents you'd like into the record.
Good morning. Scott Myers. I live at 709 Chancellor Drive in Lutz, and I have 3 letters here that apparently missed the deadline that I'm handing in hard copies of.
All right, absolutely. If you could sign in and submit your documents into the record. Thank you. All right, Ms. Shelton, I apologize. So the drain field is not, if it were to go in the 30-foot setback, it would require a variance.
Yes, I just wanted to point out that it will not be part of this variance. It would have to require a separate
Because they didn't
variance at
request
that
it.
point. Correct, it's not shown on this plan.
Okay. And I know, you didn't make the plan, but does there appear to be any area other than that setback area to accommodate a drain field?
I'm not sure if they're allowed to put it in the front setback, but I don't even know if that would get it 75 feet away from the adjacent well.
Right. Okay. I appreciate that follow-up. Is that the end of your comments?
Yes, that's it.
All
Thank
right,
you.
Perfect. Thank you. Mr. Hisney, regarding that, the drain field for the proposed septic, could it go in the front yard?
Yeah, I mean, there's not a zoning prohibition. Whether there's any other kind of prohibition from the permitting agency for the drain field, I would not know, but
Okay.
there's not a zoning prohibition against it.
All right. And regarding the approval of the non-conforming lot, that established that the lot was created before a certain date. Is that correct?
Yeah, it was created by a recorded deed prior to July 26, 1989. Looking at that NCL letter. It does not appear that it was platted. It appears that it was created by meets and bounds legal descriptions prior to July 26, '89.
And do you know if at that time the property was zoned ASC1?
I do not know.
Okay. So if it were, let's assume for the discussion, that it was zoned ASC1 and it clearly is less than, well, I apologize. So the upland acreage is less than an acre. That's the issue in terms of the septic tank.
Right, the upland. Well, two things, yes. With regards of using a septic tank, that requires 1 acre of upland. The zoning requires a 1 acre lot size of which 20% can be wetlands. But in this case, because the vast majority of the lot is in submerged lands under the lake, then it does not meet either of the requirements, either by zoning, because the submerged portion of the lot does not count toward lot size. So it doesn't meet either the zoning requirement or the septic tank requirement.
And so the determination that it's a non-conforming lot only speaks to the fact that it was created before that date in July of 1989?
Yes, ma'am, because the code has basically an amnesty date, so to speak, of July 26, '89, and if it was created by a recorded deed prior to then, then it can be certified, it must be certified as legally non-conforming.
All right, thank you so much. All right, so now the last part of the hearing is we go back to the applicant, who has 5 minutes for rebuttal.
Thank you. Just a couple notes about some of the comments. The filling that occurred way back when, we had nothing to do with that. I just want to be clear on that. There did appear to be something done, but it would have been long before we ever even knew about that neighborhood. The neighbor's house across the street is as close to the street as we propose to put our property.
Do you agree that the gentleman said that house has been there since the 40s?
It has been.
Okay, thank you.
Mm-hmm. And it's not been improved or anything, but it's there, directly across the street. The parcel that one of the speakers referenced, we owned that parcel and we owned all those wetlands and we didn't touch any of them. We did develop it. It was an 8-acre parcel. We put 2 homes on it, 4 acres per parcel. So, I mean, I don't feel like the characterization was fair. It wasn't a McMansion. They're beautiful homes. And I think that is it. I think that's it. Thank you. I think Jesus wanted to speak now.
Sure.
Thank you, Madam Hearing Officer. And I'd just like to speak to the opponents, Mr. Michael to the south. As you heard, the wetland impacts filling that occurred, my client, Rosemary Curtis, does not have any knowledge of that or is not aware of that being done under her purview or her jurisdiction or ownership. The 5-foot setback that we're talking about, again, is just for a porch. And if you look at the plan, we're looking at putting that porch on elevated pilings, if you will. So we're trying to keep the bottom pervious. I mean, it's only for I don't have the measurement. I can scan it or I can revise the plan and provide that to you, but it's for a significantly smaller portion, a smaller segment of the whole north to south wetland setback that's on there. That 5-foot setback is just for a small corner of the porch, so it's not for the whole building. Just want to emphasize that. The well and the septic tank will have to be permitted through the Department of Health. That's just another step that's just has to be done, so we're not proposing that at this time, but we will be compliant with the Department of Health regulations and any other mitigation measures that we need to do, obviously to serve utilities to the parcel. Mr. Simmons had a concern about the wildlife and whether or not I believe the lot should be developed or not. I guess at this time, it was developed by Meets and Bounds in 1989. It is a non-conforming lot, that's understood. We're doing the best we can with the little sliver of space that's available to us. So we're not trying to impact any of the adjacent neighbors beyond anything that we're trying to be as compatible as possible with the limitations that we have. Without these variances, it would be an undevelopable lot, and which is an undue severe hardship on my client. And that's the only thing I could say to his concern about development. Wildlife, we are proposing additional plantings within the setback buffer. And I'm sorry, this microphone volume is going up and down. And Mr. Rams, again, his concern was about the setback, emphasized it's only 5 feet. The maximum encroachment is 5 feet. Most of it is 15 feet. And again, whether or not it's feasible for development, in my opinion, that's irrelevant. This is an undue, serious hardship if both of these variances are not offered to my client at this time.
Last question regarding you heard the staff testify that if you were to propose to put the septic tank drain field in the wetland area setback, you'd have to come back and ask for another variance.
Yes, ma'am. No, we wouldn't propose that. That would definitely not be a fly. That would not be a go by the Department of Health. It'll likely be in the front. But again, and the drain field, in case anybody has any questions, this might be an elevated mound type drain field where, depending on the infiltration rates of the soil, it might need to be elevated and pumped into that, and it might just be a mound, just an elevated mound in the front. It's not visually obtrusive. It's not an aesthetic eyesore. It would just be what we need to do to provide septic service or wastewater service to this client.
So the property owner to the south who is concerned about the 75-foot distance that's required to his well from your
Yes, ma'am.
facility, is that, I'm trying to see this scale, again, the scale of site plan is so small. What is that width of the frontage? What's the lot width? What is that
I
number?
gave my plan. Let me. From north to south?
Yes, from north to south, yes. I brought my magnifying glass for this case, but it's still not helping. So if you could help me along, I appreciate it.
Description on there. Can I zoom through here?
If you pull that microphone over towards you, yeah.
Can I zoom in on this?
I
Zoom.
believe you can.
Here it is.
Hold on,
Oh,
we're sending
wrong way.
you home. So 148.21, is that what I see?
Do you see that?
Yes.
Okay.
All right. So 75 feet, then is it your testimony that there's opportunity to meet that distance to his well? Not knowing where his well is?
Yeah, we haven't surveyed the well. I'm not sure how far it is from his property line, but at 148 feet, in theory, if you stick that right in the middle somewhere, you have 75 feet from the north to the south. I mean, and I don't believe the property to the north is, it's not immediately adjacent. Again, I don't know what the well is on the property to the north. What was the question?
Show you where the well is.
Would that be agreeable?
Just to finish that testimony, come back up, yep, and just give us your name and address, just for the record. Go ahead and come up. And you could put that.
You can bring it right here.
Sir, you can put it on the overhead. You have to be on the record. And just give us your name real quick.
Charles Michaels.
Thank you.
And I'm in that house right there, 175.
And approximately where is your well? Is that the red?
Is that the well?
No, the well is a white dot right here.
Yeah.
The well is a white dot right to the north of the house. And this black line here was drawn by Kevin at the Environmental Division of the Health Department when he was looking at this as to if he thought it could be done and not encroach on my well. That's 75 feet. And so if you take that and you go twice across the front, that's 150 feet.
Understood.
And, but this over here is all wetlands. And see, any septic has to also be 75 feet from the wetlands. And if you go 25 feet back from the, or 5 feet back from the road, that only is 20 feet, there's just not room.
All right. Thank you. That answers the question. Can you submit that graphic into the record? Thank you so much. I appreciate the testimony. Sir, I'll let you have the last word on rebuttal.
One other thing, the upland part is 0.33 acres.
Thank you so much.
That's it.
Appreciate
Thank
it. Sir, you can have the last word before we close.
Sure. Thank you, Mr. Michael. Yeah, thank you for bringing that up, help clarify. Again, I mean, I hate to say this, but The well and the septic is not a reason to deny these. This is not, that we're not, we can discuss the feasibility of those. However, the permitting of that will be done through a separate agency, the Department of Health. And as I mentioned before, I've personally done mitigating measures for these to prove that, or to provide sufficient reasonable assurance to the permitting agencies that there would not be impacts. So we may not be able to meet the 75 feet to the north because of the wetlands that are adjacent there. However, we would do mitigating measures for such a well and septic if that was necessary, and would find that out through the Department of Health permitting.
Understood. Does that complete your comments?
Yes, ma'am, unless you have any other questions.
No further questions. Thank you so much. I appreciate your testimony. With that, we'll close variance 23-0304 and go to the next case.
Our next case is item F3, variance 23-0344. The applicant is J. Bartlett Incorporated. They are requesting a variance to encroach into the required wetland setback. Staff findings will be presented by Carla Shelton.
Busy day for you, Ms. Shelton. Good morning.
Good morning. The applicant is requesting a variance from the 30-foot wetland conservation area setback requirement, section 4.01.07B of the Land Development Code. The applicant's specific request, as shown on the site plan submitted on March 29th, 2023, is to allow for the construction of a swimming pool, deck, retaining wall, and screen enclosure within the 30-foot wetland conservation area setback. Per Land Development Code Section 4.01.07B4, no filling, excavating, or placement of permanent structures or other impervious surfaces shall be allowed within a 30-foot wetland conservation area setback. The applicant requests construction of a swimming pool, deck, retaining wall, and screen enclosure within the 30-foot wetland conservation area setback. The applicant requests a 13-foot encroachment into the setback to allow for a remaining setback of 17 feet. Staff findings. A permit for the swimming pool was issued by the building department on October 19th, 2022. This permit application was mistakenly not sent to the Natural Resources team for review, and the wetland setback was not noticed. The permit was issued and construction of the pool began. When a separate permit application was submitted for a retaining wall at the edge of the pool deck, the Natural Resources team reviewed this application and discovered the pool was being constructed in a 30-foot wetland setback area and required a variance application for the pool, retaining wall, and screen enclosure.
Thank you. I appreciate it.
Yes.
Is the applicant here? Good morning.
Good morning. Jill Mesnikoff, and I'm a representative of Bartlett Custom Homes, who's the general contractor for the house.
If you could please give us your address.
My address or the home address?
Whatever address you'd like to give us.
The home address that we're here for is 16161 McArn Trail in Odessa, Florida.
Thank you so much.
Carla mentioned correctly, so we obtained the building permit. Then the pool company, who we subcontracted out to, then submitted for their pool contract, which was approved. They started the pool, so the pool was probably 3/4 of the way finished now. We, as the general contractor, were taking over to put the deck and the retaining wall on it, so we submitted the permit, the request for a permit for that, and that's when it was determined that the pool was already almost 10 feet into the setback area. So in conversations with the county, it was determined that we needed to submit a new, to try to get a variance for the 13 feet. And we feel that, the pool's probably there, it's probably 10 foot into the wetland area now. An additional 3 feet would be required in order to put the deck and then a retaining wall, which will help mitigate any more erosion into the wetland area as well, too.
And just to be clear for the record, you're not actually going into the wetland, it's the wetland setback, correct?
The wetland setback, I'm sorry.
All
Yes.
right, thank you. That was my only question.
Yes.
Thank you so much. If you could please sign
Thank
it. Absolutely. Is there anyone here that would like to speak in support? Anyone in favor? Seeing no one, anyone in opposition to this request? No one. Ms. Shelton, anything else? All right, ma'am, you have the last word if you'd like it, but you don't have to take it. All right, thank you. Then with that, we'll close variance 23-0344 and go to the next case.
There are no sign variances today, so that takes us to section H of the agenda with general variances. First case is item H1, application number 23-0048. The applicant is Teresa Hernandez, and the request is a variance to lot development standards. Staff findings will be presented by Tim Lamp.
Good morning.
Good morning, Tim Lampkin, Development Services. The applicant is requesting variances to accommodate a proposed two-lot subdivision of property that's zoned AS-1. Additionally, the applicant is requesting a variance to accommodate an existing single-family home on the property. Per Land Development Section 6.01.00, a minimum lot width of 150 feet is required in the AS-1 district. The applicant requests the following. Variance 1, a 48.57-foot reduction to the required lot width for proposed Lot 1 to allow a lot width of 101.43 feet. And number 2, a 45.04-foot reduction to the required lot width for proposed Lot 2 to allow a lot width of 104.96 feet. And the third variance would be the existing home per Land Development Section 6.01.01. A minimum side yard setback of 15 feet is required. The applicant requests a 6.5-foot reduction in the required side yard setback to allow a side setback of 8.5 feet from the north property line on proposed Lot 1. Staff findings, per the revised subdivision plan submitted by the applicant on May the 9th, both of the proposed lots will exceed the minimum lot area of 43,560 square feet or 1 acre. Per Land Development Section 6.07.02.C.A, fences are regulated in the same manner in residential districts, except under certain circumstances that do not apply to this case. Per Land Development Section 6.07.02.C.1.A, fences over 4 feet in height shall not be allowed within required front yards in residential districts. There is an existing 6-foot-high fence that will be located in the required front yard of both proposed lots. However, the applicant has advised staff they intend to remove the fence and therefore have elected to not include a height variance for the fence in this application. And additionally, an existing carport on proposed Lot 1 encroaches into the required 50-foot front yard setback on proposed Lot 1. Additionally, a small accessory structure on the south side of that lot does not meet the 3-foot setback required for accessory structures. However, the applicant has also advised staff that they plan to remove both structures and therefore have elected to not include setback variances for them in this application. And that concludes staff's presentation.
Thank you so much. I appreciate it.
Thank you.
Is the applicant here? I understand the applicant is virtual.
Veronica, you're currently muted. If you would hit the mute button on the bottom.
Yes.
Go ahead, we can hear you now.
Thank you. I'm Veronica Zapata, the applicant representative to property owner Teresa Hernandez, address 310 12th Street in Waimama, an employee of Global Project Surveying LLC, the surveyor and mapper company, hired to divide the parcel in two and apply for a variance to lot development standards. To back up what Mr. Lampkin was saying, we have 3 variances to request to have the potential of dividing this property. The existing property has an existing house, and the property is 2.28 acres in size. The owner would like to reduce their size of the lot and leave the potential for development of the remaining land of the division. Upon completing a pre-submittal meeting for this proposed division, A variance to lot development standards was recommended by the zoning department, such that the current front width of the property already does not meet the minimum frontage width of 150 feet. It is 101.43 feet wide. Thus, variance 1 is that proposed lot 1 requests a variance of 48.57 feet from the required front lot width of 150 feet, resulting in a front lot width of 101.43 feet. The proposed lot 2 will also need a variance to lot development standards, such that a reduced lot width will also have the respect of the land development code for the setbacks and the areas. Thus, the second variance is that proposed lot 2 requests a variance of 45.03 feet from the required front lot width of 150, resulting in a lot width of 104.97 feet. It is also noted that the neighboring parcel of the south does have a lot width less than 100 feet. So, furthermore, as the variance was in process and reviewed by our planner, we noticed we will also need a third variance for the proposed lot 1 to request 6.5 feet from the required setback of 15 feet, resulting in a side setback of 8.5 feet. The existing home has been built in 1960, and throughout the years, the neighbors have not had complaints. So in the property's history, the building was approved and is now violating the land development code. And requiring reconstruction would incur high costs and be unfeasible for our client. Finally, these three variances together consider both the public and the owner property rights be respected. The owner will be able to divide the property, keep their existing home with less land to care for, all the while keeping public rights in consideration. Thank you.
Thank you for that. I appreciate it. Is there anyone in the room or online that would like to speak in favor? Anyone in support? Seeing no one. Anyone in opposition to this request? All right, no one. Mr. Hisney, anything else?
No, ma'am.
All right, ma'am, you have the last word if you'd like it.
Thank you. That's all.
All right, thank you. Then with that, we'll close variance 23-0048 and go to the next case.
Next case is item H2, variance 23-0273. The applicant is Kelly Conti, requesting a variance to lot development standards. Staff findings will be presented by Isis Brown.
Good morning.
Good morning, Isis Brown, Hillsborough County Development Services. This is case variance 23-0273. The applicant is requesting a setback variance to accommodate a proposed single-family dwelling on a property zoned AS1. Per LDC Section 6.01.01, a minimum rear yard setback of 50 feet is required in the AS1 district. The applicant requests a 24-foot reduction to the required rear yard setback to allow a rear yard setback of 26 feet to the northern eastern portion property line. Staff findings: a minimum lot of 1 acre is required in the AS1 district. The subject site is approximately 0.47 acres in size and therefore is non-conforming. However, it was certified as legal non-conforming lot per NCL 22-0786, which is in the case record. Additional findings: the site originally submitted by the applicant depicted a required 50-foot front yard setback on the northwesterly side of the subject property due to the presence of an adjacent unimproved road. However, the northwestern side of the parcel actually abuts the driveway extension of a flag lot, not a road, and therefore only 15-foot side yard setback is required along that portion of the property. This ends my report. I'm available for any questions.
No questions at this time, but thank you so much. Is the applicant here?
I believe we have Kelly online. Can you hear us, Kelly?
I can. Hi.
Go ahead.
Hi. My name is Kelly Conti. My address is P.O. Box 34, Wimauma, Florida 33598. We would like to request a reduction of setbacks for the rear setback of 24 feet Currently, the current zoning does not, or the current code does not allow for anything to be built on the home. The rear and front setback would be 50 feet, and that takes up the whole property. So we're requesting a reduction of 24 feet.
All
That
right.
is all.
All right, thank you so much. I appreciate it. Is there anyone in the room or online that would like to speak in support? Seeing no one, anyone in opposition to this request? All right, don't hear from any. Mr. Hisney, anything else?
No, ma'am.
All right, then Ms. Conte, you have the last word if you'd like to add anything before we close.
No, thank you though.
All right, thank you for that. Then we'll close variance 23-0273 and go to the next case.
Our final variance today is item H3, application 23-0276. The applicant is David Scott Gempudis. They're requesting variances to the Citrus Park Village Development Standards. Staff findings will be presented by Israel Monsanto.
Good morning.
Good morning. Israel Monsanto Development Services. This is variance application 23-0276. The applicant is requesting today variances from the requirement found in the Land Development Code section part 310.00 Citrus Park Village Development Regulations. The site is located at 7403 Ardenwood Street in Tampa and is approximately 0.13 acres in size. The site is within the CPV I-1 sub-district. The applicant is currently developing a single-family home on the parcel. According to county records, a building permit was approved and issued on October 31st, 2022. After approval of the permit, and while the single home was being constructed, staff found that the project had not been reviewed for compliance with the Citrus Park Village single-family home design standards. As a result, a stop work order was issued. The home was about 50% complete at the time the stop work order was issued. The Citrus Park Village Development Regulations requires for specific site and building design standards for single-family homes, including garage door placements, facade design, foundation, height, and window placement. Per the submitted single-family home floor and elevation plans, the project is not meeting a number of these Citrus Park Village standards. The applicant requests a total of 6 variances pertaining to single-family home structures, including variance to the building foundation, provisions of a stoop or porch, entryways, facade requirements, garage placement, and window requirements. If approved, the single-family home would be allowed to be built and completed as designed per the approved building plans and not meet 6 of the standards from the Citrus Park Village regulations for single-family home structures. And I'm available if you have any questions.
No, I've read the backup. I understand it. Thank you so much. I appreciate it. Is the applicant here? I understand the applicant is virtual.
Shane, I believe you're muted at the moment.
You're in the room. Here you are. Go ahead and come forward.
Yeah, I'm also online as well.
Yes, the homeowner will speak after.
Okay.
My name is Jeannie Gambutis, 22810 Bay Cedar Drive, Land O'Lakes, Florida, 34639. I represent the builder. I'm one of the owners. I'd like to say that we did go through the permit process. We did get approved. We were halfway through the build when we were informed of the variance. There's nothing we can do to change it now. We would if we could. Had we been told during the permit process, we would have followed everything through that Citrus Park would have wanted. Last month we did appear here because it was an administrative error. We were approved to get our money back. We did everything we could to secure the home. In this particular neighborhood, there is a lot of vandalism. We did our best to secure it for the weather. We're talking about, hundreds of thousands of dollars that were with this home and with our client. We've been working with Mr. Israel Monsanto closely. He's been very nice and very helpful. But this is not our fault. It was due to the error during the permit process. We're asking if you do approve it as soon as possible. Our client they were living in Massachusetts while we were building this, and they do not have a home to move into. The permit is locked. there's nothing we can do. Him and his wife are sleeping on friends' couches right now. They can't afford to pay the mortgage, which they're paying on right now, and rent a home. So it's pretty dire right now for them. Lastly, both ourselves and our client have suffered financial harm from this. And we ask that you do the best that you can for the both of us. Thank you very much.
Let me just clarify.
Yes.
So the administrative approval was for the fee waiver for this
Correct.
application? Okay.
Yes.
And then you're asking for an expedited review?
Yes,
for it?
please.
I understand. Okay.
Thank you.
Perfect. Thank you. If you could please sign in. I
Yes,
appreciate
thank
it.
you.
Now, did you say the homeowner wanted to speak?
Yes, he does.
Okay.
Hi, I'm here. Can you hear me?
Yes, I can hear you.
Okay. I'm Shane Bishop, 7403 Ardenwood Street, Tampa, Florida, 33625. So as Jeannie stated, yeah, my wife and I currently moved down from Massachusetts. I'm originally from Tampa, moving back to the area. We've been working with David and Jeannie for the build for several months now. Everything was going along smooth because, like as they were stated, that we were 50% through the build. We had already at that point had to make arrangements for work, for living situations, for lease breaks in our apartment in Massachusetts. There was really nothing, that we could do because we had to make those arrangements prior. As you know, you can't wait till the last minute. So right now, yeah, we are trying to find any type of temporary housing that we can, just because this has, obviously delayed the completion of the home.
All right. Thank you for that. I appreciate it. All right. We'll ask for anyone that would like to speak in support. Anyone in favor that would like to testify? Seeing no one. Anyone in opposition to this request? All right. No one. County staff, anything else?
No, ma'am.
All right. And we'll go back to, ma'am, you have the last word if you'd like it. For a rebuttal. Okay, you're good. Thank you. Then with that, we'll close variance 23-0276 and go to the next case.
We have no appeal request today, so that takes us to section J of the agenda, special uses. First case is item J1, special use application 23-0106. The applicant is the Redlands Christian Migrant Association, requesting a special use for a proposed school and a variance to lot the development standards. Staff report and recommendation will be presented by Colleen Marshall following the applicant's presentation. Planning Commission staff will also be providing comment on this through virtual attendance.
All right. Thank you, Mr. Hisney. Now, as I mentioned, special uses, the applicant goes first. So is the applicant here?
Good morning, Madam Hearing
morning.
Officer. Chris McNeil with McNeil Engineering on behalf of the applicant. Address is 15957 North Florida Avenue. Madam Hearing Officer, this is, as Mr. Hisney had mentioned, on behalf of RCMA. This is specifically for their Waimama Academy at the Bethel Mission. The location of this project is on 301 in Waimama, south of Sun City, and their existing operation areas, it has multiple ministries that operate on the facility. One of which is RCMA, and they have a full child development center, daycare, and K-8 school. There's also the Bethel Mission is on there. I've highlighted the entire property in this area below that includes both of those. I'm going to zoom in a little bit for you on that. The overall property use map here and the special use boundary shows both. The property is the outline perimeter. This more bolder dashed area is the special use area, which includes the existing K-8 school for 320 students, and also the additional 2 properties that we're talking about today that we were adding to the special use. This plan is the special use plan that's submitted. Again, just zoomed in a little bit further just to identify the special use area. Again, the existing Waimama Academy, 320 students. max and this area over here for there to be the ancillary recreation area, which is currently being used as such. The applicant was made aware that they needed to have the special use extended when they tried to get a building permit to cover the existing basketball court, and that's kind of what set this in motion. This is an aerial background imagery to show you kind of what's going on in the area. I've highlighted that basketball court that we're talking about. To the north, you have some commercial outdoor storage operation. To the south is vacant residential, which looks largely wetland. As part of the request, there is a setback reduction request. It's noted here. I noticed in the write-up that it says 8.55 in the write-up. It's shown 8.56 here, which is okay, but in the request it was 8.5. I don't know if the record could be 8.5, just to give a little bit of room there, just in case there's some difference in survey. If not, that's okay. With that, I just want to say, just from RCMA, again on their behalf, they were in the Hillsborough County in 1975. They've been here for almost 50 years. They have several different mission locations, 17 in the county to be exact. Great operation, great things that they're doing. It's a much needed area. They focus on migrant students, migrant farm worker students, and also any of those same kids with disabilities. They mainstream them. So they teach them here on campus all the way through from the VPK through K through 8. And they need more resources to expand. This is just part of that expansion to give them some recreation area outside. So we appreciate your consideration. I'm available for any questions should you need.
Just two questions for the record. First, no increase in students, is that correct?
Yes, ma'am, that's
All
correct.
right.
No increase.
And then I think you answered my question. I had a question about whether that sport court was existing, and it is. And so the cover is just to go over that existing basketball court.
Yes, ma'am, that's correct.
Perfect, that was it. Thank
Okay.
you so much. If you could please sign in. All right, Development Services. Good morning.
Good morning, Colleen Marshall, Development Services. The applicant stated the request today is for a special use permit for an existing charter school at 18234 U.S. Highway 301. The school was first approved in 2000 for 120 students in grades K through 6 under special use permit 00-0573, then expanded in 2010 by special use 10-0459 to increase the number of students to 320 and allow middle school grades. The purpose of this special use application is to incorporate two adjacent parcels to the east at 3128 and 3143 Willow Road that have been utilized by the school for recreation purposes. The subject request will merge the existing school site with the proposed recreation areas and play courts under one common special use permit. No changes are proposed to the number of students permitted at the school, grade levels, or building gross floor area. A 6,000 square foot metal canopy is proposed over the existing play courts. In connection with special use 10-0459, a variance was approved for the required rear yard setback along the eastern property boundary of the existing school property, folio 57987.0000, to allow a 25-foot setback along the eastern property boundary of the existing school property. The approved variance has been reflected on the proposed site plan. The applicant's requesting a variance to the required rear yard setback for the proposed 6,000 square foot metal canopy over existing play courts. Per section 60101, a minimum 50-foot rear yard setback is required in the AS1 district. The applicant requests a 41.45 foot reduction to the required rear yard to allow an 8.55 foot rear yard setback for the proposed canopy. No agency objections were received by staff. Staff recommends approval subject to the conditions contained in the staff report.
Thank you. I just want to follow up on Mr. McNeil's clarification of that setback for the canopy. He has it as 8.56.
Yes, so I did see, it looks like it was a little bit hard to read on the site plan just when I had it printed out, but it looks like the request statement indicated the 8.55. Maybe that was done for clarification or for leeway, but there would be no issue.
So the math would be 8.55 based on his request for the reduction. Is that how we got there?
The plan showed 8.56. The request was
Oh,
for
I see. All right. So
8.55.
We'll pick this back up at rebuttal to clarify how you'd like to proceed. So, but either, I'm assuming either is fine with you. I just want to make
Correct.
sure we have the right amount.
Yes.
Okay. Thank you so much. I appreciate it. All right. We'll go to the Planning Commission.
Hi, good morning, Madam Hearing Officer. Can you hear me okay?
I can.
Okay, great. This is Jillian Massey with Planning Commission staff. The subject site's located in the Residential 1 Future Land Use category. It's in the rural area and within the limits of the Little Manatee South and South Shore area-wide systems community plans. The proposed improvements for the recreation area are low intensity in nature and will allow the site to remain rural in character. Therefore, the proposal is consistent with Objective 8 and Policy 8.1 of the Future Land Use Element. The proposed rezoning, or the proposed special use rather, meets the intent of Objective 16 and associated policies relating to neighborhood protection. The site's surrounded by existing recreational uses on site, conservation land, and some light commercial uses, as well as single-family residential uses. The existing vegetation and conservation land on and surrounding the site acts as a buffer from the surrounding uses. And furthermore, the main access to the site is located off US Highway 301 with emergency access limited to Willow Road, which will restrict traffic from the single-family neighborhoods in the area. And therefore, the proposal is consistent with the existing surrounding development. Also, the proposal meets the intent of Objective 17 and Policy 17.1 as the school's residential support use. And the improvements are designed to fit the character of the neighborhood. And residential support uses are allowed in all future, residential future land use categories. The subject site meets the intent of the Little Manatee South and South Shore area-wide systems community plans, as schools, recreational amenities, and public services are identified as goals. The proposed improvements to the recreation area will serve an existing school and church site and further the goals outlined in the community plans. And with that, based on these considerations, Planning Commission staff finds the proposed special use consistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the conditions proposed by the Development Services Department.
Thank you for that. I appreciate it. All right. Now we're to call for anyone who would like to speak in support. Anyone in favor? Seeing no one. Anyone in opposition? Okay, no one. County staff, anything else? Nothing? Okay, thank you so much. All right, Mr. McNeil, we'll go back for a rebuttal. And just to clarify that exact request for the reduction and the resulting setback.
Yes, ma'am. Just to point out where this is exactly, this is the existing basketball court. The buffer or the setback we're talking about is at this location between the two properties within the limits of the special use. And zoomed in here a little bit more, this is the actual plan. It shows a dimension on the plan of 8.56. When we submitted the variance narrative, we made that 8.5 just in case there was any kind of, if somebody else surveys it and it's off a half an inch, we didn't want them to be subject to the 8.55 or 8.56, but 8.5 would be preferred if staff is okay with that.
All right, so just 8.5.
8.5, correct.
We'll go back to staff. It's a very fine point, but Mr. Hisney, Ms. Marshall.
Yes, ma'am.
The question is, would just revising that resulting setback, clarifying to leave it at 8.5 rather than?
Yeah, no objection to the clarification.
All right, thank you so much. Is there anything else you wanted to add?
No, ma'am. We thank you for the opportunity.
Thank you, I appreciate it. Then with that, we'll close special use 23-0106 and go to the next case.
Next case is item J2, special use 23-0145. The applicant is Tampa Electric Company, requesting a special use for a radio and television transmitting and receiving facility. Staff report and recommendation will be presented by Tim Lampkin following the applicant's presentation. Planning Commission staff will also provide comment on this request.
All right, thank you very much. Is the applicant here? Good morning.
Good morning, Madam Hearing Officer.
If I could approach, I have a notebook for you. They are all documents, I believe, that have been submitted into the record, but I want to make sure that they've got to you.
All right, certainly. So just to clarify that for the clerk, excuse me, these are all documents that are existing in the record? That's correct. Okay, thank you.
So, some of the documents came after the revised site plan cutoff most recently, so I just want to make sure. For the record, Michael Brooks, 400 North Tampa Street, here in downtown, 33602, here on behalf of Tampa Electric Company. I will keep my presentation brief, Ms. Finch. The documents that I gave you are related to, first, in the first section, the special use application itself, of course, the written statement, copy of the site plan. This tower did go through technical review. There's a cross-reference, and you may be aware of this from other cases. Our land development code divides towers into two categories, essentially based on height, although one of them, in fact, those are over 200 feet, are radio and television towers. This is, of course, for a TECO facility. Through that cross-reference, the need provision of the other section comes into play, and so there was a third-party technical review that was done as well. Also in here is the Federal Aviation Administration's determination of no hazard for the existing tower. We've included the historical FAA aeronautical study number, 82 ASO 1714. That was constructed sometime in, we think, like around 1982, 1983. The replacement tower has also been to the Hillsborough County Aviation Authority. On May 4th, the Aviation Authority Board of Adjustment approved a height variance for the replacement tower and also issued the permit. Those are in your backup documents as well. I have with me Jeff Ogden, the telecommunications manager for TECO. I'm going to offer him just for questions. I think we've well documented both the need and the third-party regulatory approval, so this is the last stop.
Just to clarify, just to make sure I understand, so this is an existing 600-foot tower?
Yes, ma'am.
And is being replaced just for technological purposes or something?
So this is part of a resiliency improvements that TECO is going through. The tower was built over 40 years ago, and so it is in need of replacement. It is a guide tower, and it's kind of reached the end of its life period.
And the same location as the existing?
It will be roughly 25, 30 feet near the existing location.
All right, I think I've read all the backups, so I don't think I have any more questions than that. Thank you. If you could please sign in, Mr. Brooks. All right, Development Services.
Good morning, Tim Lampkin, Development Services. For special use, RFF 23-0145, which is a request pursuant to Land Development Section Code 6.11.79. The request is for a special use permit for a radio and television transmitting and receiving facility with a 600-foot high antenna tower located at 820 South 78th Street. Staff findings, I'm going to do an overview of staff findings because Mr. Brooks did a thorough job, and there's a lot of background documentation. The proposed tower exceeds the setbacks required by the Land Development Code, Section 6.11.29, which Section 6.11.79 references back to Section 6.11.29. The host parcel is approximately 63.1 acres in size, and it's zoned M and Planned Development District. The site plan submitted by the applicant shows the proposed tower will exceed the minimum setback requirements found in the Land Development Code, Section 6.11.79.g, which are 1 foot of setback from the zoning lot line for every 3 feet of tower height. Per Section 6.11.79.b, no camouflage is required for the proposed tower due to its location in the M zoning district, and no camouflage is proposed. Per section 6.11.79H, proposed radio and television transmitting and receiving facilities, except for such facilities that will be utilized for the transmission of radio and/or television signals, need to be documented. And as the applicant said, such a documentation was forwarded by staff for review by our outside expert, who found that there are no viable support structures in the area that would allow the applicant to co-locate its communication antennas and meet the needs of the mission-critical communication system. Pursuant to LDC section 6.11.79C, the applicant also submitted documentation, which they may have resubmitted today, showing that the Hillsborough County Aviation Authority has reviewed the proposal as required by the airport zoning regulations, determining that there is whether or not if there is any potential impact on public airports in Hillsborough County. The submitted document shows that the Hillsborough County Aviation Authority Board of Adjustment approved a variance to permit a maximum tower height of 618 feet above mean sea level. The applicant has sought no waivers to the regulations contained in section 6.11.79, nor any other variances. Staff finds the proposed tower is consistent with the surrounding uses and compatible. The surrounding area is zoned and developed with industrial and commercial uses, and the nearest residential property is over 1,700 feet to the west. Additionally, as the applicant did note, the proposed tower will replace an existing tower of approximately the same height. Planning Commission staff found the tower consistent with the comprehensive plan. For the reasons discussed above, staff finds the proposed subject use approvable, subject to conditions. I can read the conditions if you'd like. They are in the report.
Yeah, it's not necessary, but
Okay.
thank you. I appreciate that.
Thank you.
And no questions, so thanks.
Thank you.
All right, we'll go to the Planning Commission.
This is Jillian Massey with Planning Commission staff. The subject site has a future land use designation of light industrial plant. It's in the urban service area and within the limits of the Greater Palm River Community Plan. The proposed tower will be placed in an area that already has an existing public utility and communication use and will not significantly change the existing character of the area. The subject site is not encroaching onto residential uses that are located directly west, thereby meeting the intent of the neighborhood protection policy direction under future land use element objective 16 and policies 16.1, 16.2, and 16.3. The proposed special use also meets the intent of future land use element objective 9 and policy 9.2 and objective 46 and policies 46.1 and 46.2 that require telecommunication towers and facilities to be in areas with compatible land uses and adhere to all local, state, and federal laws. The proposal meets all setback requirements, and the applicant is not requesting any waivers to the requirements. The proposal meets the intent of Goal 5A of the Greater Palm River Community Plan. Under this goal, Strategy 14F seeks to ensure that commercial intersections reflect a character that is compatible with the surrounding neighborhood land use structure and intensity. Palm River Road and 78th Street is one of the targeted intersections under this goal. The proposed tower reflects uses that are compatible with the surrounding neighborhood uses and intensity, and therefore is consistent with the intent of the community plan. And based on these considerations, Planning Commission staff finds the proposed special use consistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the conditions proposed by the Development Services Department. Thank you.
Thank you very much. I appreciate it. Is there anyone in the room or online that would like to speak in support? All right, seeing no one, anyone in opposition to this request? No one. County staff, anything else?
No, ma'am.
All right, thank you. Mr. Brooks, anything to add?
If I could just, a brief minute, clarification. So you heard two numbers regarding the height. The 600 foot is the above ground. The above sea level height for this is 618. The sea level elevation is about 18 feet at the location. There's a C1 survey in the backup that demonstrates that. The other thing I want to point out is that in the original written statement. There were proposed conditions that are not part of the conditions that Mr. Lamkin had identified. Those were related to, because there are public records protections for the facility and some concerns about demonstrating need. Those were proposed as alternatives. We were able to bridge that to that issue. And lastly, and I do not make this request lightly, if I could ask for an expedited review. TICA was hoping to get this constructed before hurricane season begins, which is June 1st, so that's obviously not going to happen. But the earlier in the season that we can start that construction, get the equipment moved over, and get the old tower disassembled would be greatly appreciated.
Understood.
Thank you.
Thank you, I appreciate it. All right, then with that, we'll close special use 23-0145 and go to the next case.
Next case is item J3, special use 23-0187. The applicant is El Patio Hookah Lounge. The request is for a 4 COPX alcoholic beverage permit, which requires a separation waiver. Staff report and recommendation will be presented by Colleen Marshall following the applicant's presentation. Planning Commission staff will not be making comment on this application.
All right, thank you so much. Is the applicant here? Good morning.
Good morning, everyone. My name is William Quinones, and I'm the representative for the owner of the property in question at 9401 South 301 Highway. And currently, this property is permitted as a 2 COP. And what we would like to do is upgrade it to a 4 COP. What our intentions are, we're looking to open. I'm also one of the owners for the El Patio Peruvian Cuisine and Bar, and I was also, I was also the owner for the London Heights British Pub in Seminole Heights, and I'm looking to do this new location at the Riverview property, and we kind of want to follow the same blueprint that I use for the London Heights British Pub, but as a Peruvian restaurant. At my previous establishment, we were known for a destination for entertainment, good food, and fun. And pretty much, that's one of the things that we want to continue in this new establishment. Doing things such as sporting events, fan clubs for sporting events, weekly events that include live music, holiday theme parties, 80s and 90s and Latin dance parties, comedy shows, things of those nature. At London Heights, we had good food, we had good reviews, but unfortunately, because of COVID-19, we were forced to close. Shortly after that, I was struck with the COVID-19 virus. I was hospitalized for 2 weeks in intensive care, followed by 3 months of pneumonia issues, and then another 2-week stint of hospitalization. So I was never able to reopen London Heights, and now I'm ready to get back into the game and open up the Latin El Patio Peruvian Cuisine and Bar. This is pretty much what we have so far, and we're just waiting now to try and see if we could get this upgraded to the full CPX permit. Thank you.
Let me ask you a couple questions before you go.
Sure.
the staff report says that this property currently has a designation of a 2 APS, which is the package sales.
Yeah, I'm sorry, yes, APS.
So that you just misspoke?
Yeah.
Okay, understood, that's fine. And then secondly, when you sent out your notices for this hearing, did you hear anything back from the people that were in the notice list?
No, I have not.
You haven't heard anything?
No.
All right, thank you so much. If you could please sign in with the
All right,
clerk's
thank you.
office, I appreciate it. All right, we'll go to Development Services.
Colleen Marshall, Development Services. The applicant stated the request today is for a distance separation waiver for a 4COPX alcoholic beverage permit for a proposed restaurant located at 401 US Highway 301. The wet zone area will comprise a footprint of 2,166 square feet of indoor area. The original request was sought for a proposed restaurant and hookah lounge. However, the sale of alcoholic beverages is prohibited within hookah lounges within Hillsborough County per Article 19 of the Code of Ordinances, which was adopted in 2021. In response, the applicant submitted a revised narrative stating the proposed establishment will not include a hookah lounge and will operate solely as a restaurant and bar. The subject premises currently has a 2 APS wet zoning under SU-AB 80-0771 for the sale of beer and wine in sealed containers only for consumption off the permitted premises that will be rescinded if the proposed wet zoning is approved. The applicant requests a 133-foot waiver to the required 250-foot separation for the residentially zoned property to allow a separation of 117 feet. Justification for the proposed waiver is contained in the staff report. Additionally, the applicant requests a waiver to the permitted maximum of 3 approved alcoholic beverage permits of the specified types within 1,000 feet. According to the wet zone survey, there are 4 approved permits in the same classification. Justification for the proposed waiver is contained in the staff report. And staff recommends approval with one condition, that upon approval of SU-AB 230187, the existing 2 APS wet zoning of the premises, SU-AB 80-0771 shall be rescinded.
All right, thank you so much, I appreciate it. Is there anyone that would like to speak in support? Anyone in favor of this request? All right, seeing no one, anyone in opposition? All right, I have 2 people. Let me ask if there's anybody online that would like to speak in opposition.
We're not seeing anyone online.
All right, thank you. If you want to go ahead and come forward. It is 15 minutes total, so that's 7.5, but feel free not to take the entire time if you'd like. But Allison, if you could put them on the clock. Thank you. Give us your name and address.
Good morning, everyone. My name is Stephanie Greer. I live at 10609 Shady Falls Court. It is in a nice and quiet community right next to the restaurant right now, called Riverwalk. There's about 144 units in Riverwalk, and I have got a few pictures.
Yeah, absolutely. You could show them.
So I'm gonna put it here.
Okay. Just pull that microphone over towards you while you talk.
Yes,
so
ma'am.
Make sure you're on the record. Thank you.
Okay, so I'm not quite sure how to zoom. I saw other people doing it, but.
We'll send somebody over to help you.
You want to move further, or are you good? Oh, that's good. Thank you.
Thank you.
So here you see where's the patio is right now. It used to be a dentist building right there. It burned and it's not there anymore. And the wall that you see, this is the Riverwalk community. So this is, as a straight line, it says 307 feet from the corner of the building to the corner of, so it's all townhouses, so the corner of the townhouses. So this is from the corner, so the view of the building, so the distance from there to the community. And the reason why I took that is to show you, like, this is the windows. It's a clear view to the windows of the townhouses. Right now, we have on the lower part is a wood fence, but it's 2-story buildings, so it doesn't protect all the second floor where all the master bedrooms are. So I've got a few pictures like that. So again, so this is the restaurant, and the houses are right there. What is not mentioned in the presentation, so a few things. First, I wanted to say that I am a teacher in Hillsborough County, so of course I get up early. They won't open every night till 3 a.m., so that caused a little bit of a problem. There's also they're building a huge hospitals right in front of our community. It's a Advent Health hospital built on 301 that will contain about 120 rooms. And they redid all the 301 configuration right in front of it. So the first place, if you go north on 301 from Boyette Road, the first place people can turn to go to the restaurant, they need to do a U-turn. And this is right in front of where we go out of the community and where they go into the hospitals. So they're gonna eventually do a light, but this is the only place going north on 301 where they'll have access to the restaurant, which I think we're gonna have enough traffic there already and enough noise also. So yes, I think the U-turn will cause a problem. I had a few questions about it also. So it's called patio. So it doesn't, when I read the plan, the business plan, I didn't see any place that if it mentioned that they're gonna do outside activities, again, till 3 a.m. cause a problem in the community. And let me show you one more thing. So, and when we measured it, it's like to one of the building and not the closest one. There's other residential property around. So here I found in one of the paper that I said there's no community around with the 50 feet, which my drawing shows yes. And there's already 11 alcohol beverages licensed around in the area. And I thought also there were some laws or rulings against that many more.
They are asking for a waiver of that provision.
For that part,
yes.
Okay.
Mm-hmm. Let me ask you, does that complete your presentation? I want to add.
First time doing that, so I think so.
You're doing fine. The county testified, as did the gentleman, that the property where they're going to put the restaurant and lounge is already zoned or already has approval for what's called a 2 APS alcoholic beverage license. So that's for the sale of packaged beer and wine. So what is there now if you live in the community? What was that was having?
It used to be a beverage castle where you go in, with your car, get out. So
I see, like a drive-through liquor store of some sort? Okay, but that's closed, obviously?
Yeah, and I don't know since how long, a few years. I think they had I'm going to say hold up, I'm not sure. They had a criminal problem there, and I think the guy was shot, but I'm not quite sure of all that, and it was closed.
All right, and so from your pictures that you showed, it looked like from the perspective of the restaurant lounge, across that street, and then there's your community.
Yep.
There is a fence there, is that correct?
We have a wood fence, but it's wood, very limited. That had to be, with the hurricane bend down, it's not a very good. The corner is stone, but just a corner, and then after that it's wood. Like behind my house is just wood.
I see. All right, that was the end of my questions. Thank you for coming down. I appreciate it. If you could please sign in.
Yes, ma'am.
And if you'd like to submit those pictures into the record, you can do so.
I will, ma'am.
Perfect.
Thank you.
Next person. Good morning.
Morning. Richard Brennan, 10605 Shady Falls Court.
Bring that to you a little bit.
10605 Shady Falls Court. We're within 370 feet from their front door. There's bars all around there that should suffice. They are building a brand new hospital. It's directly across the street. And I got a disabled brother that lives with me, mental issues, sleeping problems, and I couldn't see him sleeping with a bar being open. We have CJ's, which is in the adjacent facility. They open their back door, we can hear their music. This place is called the Patio. I can just assume that it's going to be an outdoor venue of some sort. There's a food truck that's parked right on the front of the property that plays music now until 10 p.m., which is fine, but it's very loud. I mean, you can hear it sitting in our bedrooms. But the fence is only a wooden fence. We have concrete across the front, but it's wood across the side and across the back. The building that they said was adjacent to the north is no longer there, and that's about it.
All right, well, thank you for coming down. If you could please sign in. Anyone else that would like to speak in opposition before we move on? All right, seeing no one, we'll go back to Development Services. Let me ask about the hours of operation. What are the county limitations on that?
Colleen Marshall, Development Services. I don't have the ordinance with me offhand. I do believe it is until 3 a.m. on certain nights.
Yeah, by code,
right.
Alcoholic beverages, the sales are on Monday through Saturday. They're permitted from 7 a.m. to 3 a.m. the following day, and on Sunday from 11 a.m. to 3 a.m. the following day.
All right, thank you for that. I appreciate it. Did you have any, the gentleman, or I'm sorry, the lady that testified in opposition talked about community within 500 feet, but I believe the code requirement is a certain community uses is what that refers to, like a church or a school or something.
Correct.
And this complies with that requirement.
Yes.
Perfect. All right, that was it. Thank you so much. All right.
Also, Madam Hearing Master, if
Yes,
I may add, while there is approximately 10 or 11 wet zonings in the area, by code, only certain types of wet zonings within 1,000 feet are what matters. And in this case, of the existing wet zonings, only 4 of them are of the type that matter. And we addressed the waiver for that in our report. And then lastly, it was mentioned by both opponents, concern about, because of the name of the establishment is El Patio, that there would be outdoor consumption of alcohol, and this wet zoning actually does not include any outdoor area, so I can say that if in the future it is found that there is the outdoor consumption of alcoholic beverages in connection with this use, it would be a violation of their wet zoning. Now, I want to stress that we're talking about the consumption of alcoholic beverages. If other outdoor activities are occurring in connection with this use, that's connected to their CGU, zoning and the operation of a restaurant, which would not fall subject to this. But indeed, again, if there is found in the future to be outdoor consumption of alcoholic beverages, that would be a violation of their permit.
All right, thank you for that clarification. I appreciate it. We'll go back to the applicant, who has 5 minutes for rebuttal. Do you want to come up and address any of the comments? If you give us your name just to start.
Thank you. I just want to refer to our wet zone survey that we received from the agency that conducted the
There we go.
This part up here.
Can't do it right here, just because it's going to be
Yeah, this part here. Yeah, that's fine. Okay. As you see, it states here that there's no community users within 500 feet. And of these 11 areas that have alcoholic permits, only one, which is CJ Saloon, is actively using their full COP permit. There's others, but for example, the number 2 has a full CP, but it's a florist right now. And so we will be the second business with a Ford COP actively being used. Also, the hospital that she's referring to, we've been in planning with this business even before that hospital got there. So we've been in this process for just over a year before they started actually building the hospital. So we didn't even know that there was going to be a hospital there. And the community she's referring to at one point was blocked off by a building or a dental clinic that was directly across the street. And since then, since the time we've been there, going through this process, it's been knocked down and it exposes their property more, but I don't think that'll have any effect because we will not have any outdoor activities, as the gentleman alluded. That's not what we're applying for. Everything is inside the structure that we're located. The CJ Saloon is down the way, about 5 storefronts from us, and they've been there for a long time, and it doesn't, they haven't really caused much problems for the community. As far as the U-turning, because of the hospital and the way they configured it, we're in a shopping center that anybody that's going to go into that shopping center will have to do a U-turn, not just our customers.
Let me ask you, you hit all the points except the hours of operation. You
Yes.
heard Mr. Hisney respond to what the code requirements are. What are your proposed hours of operation?
Yes, we intend to be open early for breakfast, lunch, dinner, and on the weekends, we will have activities that would run into 3 in the morning.
All right. And just to clarify, those hours speak to not your actual serving of food, but rather the sale of alcohol.
Both. It will have food and beverage.
All right. Okay. I didn't have any other questions unless you had anything else you wanted to add.
No, thank you.
All right. Thank you. I appreciate it. Then with that, we'll close SU-23-0187. I see that it's almost noon, so let's take a 5-minute break. If you could be back, let's just say 12:05. There's a clock on the back of the wall, and we'll resume the hearing and finish it. Thank you so much. All right, we're back for the conclusion of today's land use hearing officer hearing. So with that, Mr. Hisney, if you could call the next case, please.
Our next case is item J4, special use application 23-0218. The applicant is LCS Communications. The request is for a special use permit for a wireless communications facility. Staff report and recommendation will be presented by Sam Ball. Following the applicant's presentation, Planning Commission staff will provide comment on this case.
All right, thank you so much. Good morning.
Good morning, Madam Hearing Officer. I'm Lisa Revis of Becker and Polyclough, 625 North Flagler Drive, West Palm Beach, Florida, and I represent the applicant LCS Communications, LLC. I'm accompanied virtually by our development team, which includes Jared Jackson, our civil engineer and site designer with Tower Engineering Professionals, Harold Timmons, our zoning and real estate specialist, who is also with Tower Engineering and Professionals. Jason Pauly is our radio frequency engineer with T-Mobile. And with that, a PowerPoint presentation by Mr. Timmons. Here it is.
Next slide,
He is
please.
virtual.
Hello, can you hear me?
What's his name?
Harold Timmons.
Yes, Mr. Timmons, we can hear you. Go ahead.
Thank you very much. Can you go to the next slide, please? Yes, we're proposing to construct a 125-foot tall tripole stealth concealment clock tower that will support wireless communications equipment. Next slide, and you have a graphic there of what we're proposing. The next slide, yes. As you can see there from the aerial, this indicates where the property is located within the community, basically at the intersection of Plymouth Pride Boulevard and Big Bend Road. Next slide. We're proposing the 125-foot concealment clock tower, and this is sort of a development alternative to the previously approved but never constructed childcare use that was approved on that property. The structure itself will allow for co-location of up to 4 total users. We will ingress and egress the site via Clement Pride Boulevard via an existing access easement. We have a lease area that is 40 feet by 40 feet in size. The landscaping on the site will be a combination of a type A and type B buffer. The facility will be unmanned and will operate 24 hours a day, 7 days a week. Visits to the site are basically limited to equipment support maintenance personnel, and we only anticipate only 1 trip per month, and for the most part, it'll be even less than that. Signage is limited to that regarding safety and tower owner contact, and no lighting is proposed or required for this site. Next slide. You can see the interior compound layout that we are proposing. The 40-foot by 40-foot lease area will be enclosed with an 8-foot tall chain link fence. That fencing will contain green vinyl slats to limit visibility into the compound. The compound layout also shows the future locations for possible future tower tenants. And you can see on the mapping where the type A and type B landscape buffer requirements are designated for our site. Next slide, please. Another elevation view of the structure. Again, the height is 125 feet. It is a concealed clock tower. There will actually be a functional clock at the very top. Equipment will be placed on the structure behind the enclosed, but behind the panels that you see there. It will certainly allow for the structural capability of at least 4 total users. And in terms of compatibility per the LDC, clock towers are presumed compatible with other uses when located in the PD zoning district. Next slide.
Here you see where we're going to be placing the structure on the property. It's basically centrally located within the parcel. Again, our access will be off of Clement Pride Boulevard via an existing access easement. And the proposed setbacks that are shown here actually meet or exceed the LDC code requirements for such structure. Next slide. No design exceptions or variances are needed or requested, and the request complies with all applicable code requirements. There'll be no need for tree removal. We've received no objections from county staff or the Hillsborough County Airport Authority, and staff recommends approval of the request subject to the conditions of approval detailed in their staff report. Next slide. This slide represents the existing structures that are within the area. Only one of those structures shown here is less than 1.5 miles from the proposed location. Each of these existing structures work to comprise the existing T-Mobile network. So in essence, each one of these structures already has T-Mobile equipment placed on them. Next slide. This is a radio frequency map showing coverage that was submitted into the package for our special use permit. It shows the existing structures that I previously discussed on the previous slide. And the subject site is located in the center with the blue dot. This map is representing reliable in-building coverage from the existing network. It also shows in yellow reliable in-vehicle coverage. So in other words, it doesn't have in-building coverage. Next slide. This slide shows how the coverage will change with the construction of the structure and how it will take an area that previously didn't have reliable or had reliable in-vehicle coverage and will turn it into reliable in-building coverage. Next slide. This slide was provided due to some input we received at our previous hearing. And basically what this represents is the radio frequency coverage or the radio frequency emissions that come from a tower and how it has impact or no impact on individuals or persons at a ground level. A site, emitting at 100 watts, 25 yards from that signal, the RF emission is around 0.002 milliwatts. That 25 yards represents 75 feet. And the further you move away from that, the more that that signal diminishes. And as you get out to around 90 yards or 270 feet, you get down to 0.0001 milliwatts. So it's just an indication of how the further you are away from a structure, the less of a radio frequency signal or the emissions that you receive. And given that 125-foot tall structure at the ground level or at 25 yards, we will be even less than 0.02 milliwatts. Next slide. This is information obtained from the FCC website. And we believe that the second paragraph is the most important portion of this particular statement. And I'll read it to you. Measurements made near typical cellular and PCS installation, especially those with tower-mounted antennas, have shown that ground-level power densities are hundreds to thousands of times less than the FCC's limits for safe exposure. But most importantly, this makes it extremely unlikely that a member of the general public could be exposed to RF levels in excess of FCC guidelines due solely to cellular or PCS base station antennas located on towers or monopoles. Next slide. We will sum this up by indicating that there is a radio frequency need for a tower in this location, as documented by the information T-Mobile has provided and confirmed by the county's RF consultant. As the staff has confirmed, the proposed development complies with applicable LDC requirements. The proposed concealed design conforms to the recommendations of the LDC for PD zoning districts. Landscape buffers, compound fence screening, and existing vegetation will reduce the visual impact of the ground portion of the facility. The proposed development will not be a detriment to natural resources, public facilities, or the public welfare. The proposed site, working in concert with the existing wireless network, has a public benefit, allowing for more reliable calls for businesses and residents, as well as for emergency personnel, through the use of enhanced service and location technology to assist distressed callers. We ask that the staff recommendation be accepted and that the request be approved as proposed with the outlined conditions in the staff report. And that concludes our presentation. We'll be available for any questions that you may have. Thank you very much.
Sir, can you please just give your name and address, please?
My name is Harold Timmons, and the address is 10700 Sykes Place, Suite 360, Charlotte, North Carolina.
Thank you so much. I appreciate it. Does that conclude all of the applicant's presentation?
It does at this time.
All right, thank you so much. Then we'll go to Development Services. Good afternoon.
Good afternoon, Sam Balf Development Services. The applicant is requesting a special use permit for a proposed wireless communication facility with a 125-foot tripole concealment with a clock tower camouflage that would be located on a planned development zone property located at the southwest corner of Big Bend Road and Clement Pride Boulevard. The surrounding area is developed with a mixture of religious, residential, and recreational uses. The host parcel is on Plan Development PD 81-0339 and is currently undeveloped. PD 81-0339 was recently modified by the Board of County Commissioners through major modification 230223 to allow for a wireless communication facility with the 125-foot high tripole antenna tower with clock flower camouflage to conceal the antennas to be located on the site plan that was submitted by the applicant. The PD conditions of approval require that the compound for the tower and its related equipment will be contained within a 40 by 40 leased area that will be enclosed with an 8-foot tall chain link fence. The 8-foot tall chain link fence will be covered with green vinyl slats to limit visibility into the compound. In addition, a 10-foot wide buffer with landscaping and with type B screening will be provided around the exterior perimeter of the compound. The PD conditions also require a 10-foot buffer with type A screening in accordance with LDC 60606 along the western and southern boundaries of the host parcel where the facility will be located. The applicant has submitted documentation indicating the need for the facility at a height of 125 feet for the desired coverage area and capacity needs, and that no other existing facilities are available for co-location. No objections have been received by staff from review agencies. No transportation impacts are anticipated of the proposed tower, and very few trips per peak hour are expected. Based on staff's findings, staff finds the request approvable subject to the conditions contained within the staff report. That
Thank you so
concludes
much.
my report.
I appreciate it. Planning Commission, please.
This is Jillian Massey with Planning Commission staff. The subject site is located in the residential 4 future land use category. It's in the urban service area and within the Riverview community plan limits. The proposed special use is compatible with the development pattern of the surrounding area and meets the intent of Objective 1 and Policy 1.4 of the future land use element as it relates to the urban service area. It also meets the intent of the Neighborhood Protection Policy Direction under Objective 16 and Policies 16.1, 16.2, and 16.3. It meets the intent of Objective 9 in Policy 9.2 as well as Objective 46 in Policies 46.1 and 46.2 that require all telecommunication towers and facilities to be in areas with compatible land uses and adhere to all local, state, and federal laws. The subject site is now encroaching onto residential uses that are located to the west, and the proposal meets all setback requirements and not requesting any waivers to these requirements. And based on this consideration, the Planning Commission staff finds the proposed special use consistent with the unincorporated Hillsborough County Comprehensive Plan, subject to the conditions proposed by the Development Services Department. Thank you.
Thank you. I appreciate it. At this time, we'll call for anyone who would like to speak in support, either in the room or online. Anyone in favor? All right, seeing no one, anyone in opposition to this request? Hold your hands. How many? We have 2. All right, do we have anyone online to speak in opposition?
I'm not seeing anyone online.
Okay, if you all want to come forward, it's 15 minutes total, so Allison, that'll be 7.5 apiece. If you could give us your name and address to start.
Good morning. Perry Goldberg, 12102 Cedarfield Drive. Just want to introduce myself. First of all, I spoke at the May 9th meeting where the board decided to grant the change in the PD for the use of this ground. At that point, I was going against this for 3 reasons. One was a nuisance to the residences and adjacent to the property. The second was it wasn't keeping in character with what the neighborhood was doing, and the third was the health. Obviously, Tower did a great job presenting the health issue just a few minutes ago. In looking at that, I actually spoke with our attorney, and from a legal standpoint, what they told me was that the applicant appears to have sufficient basis for the special use to be granted based on the site assessment for the associated materials. They said the best thing that we could do in looking at this, because we're concerned about obviously where we live, was to impose some reasonable, tailored restrictions to minimize the nuisance to the private property and to ensure that the available remedial and prophylactic measures are taken by the municipality, governing bodies, developers, and lessees to extent possible to protect the safety of the homeowners and protect the value of the property. So in kind of looking at that, there are 3 things that we're really concerned about as homeowners that are going to be adjacent to this. Tower stated in their presentation on May 9th to the board that there is a piece of, there's actually a construction trailer that has been temporary for the last 7 to 8 years on the property. When it came in, if I can, please. When it came in, it looked fantastic.
Just bring that microphone over towards you. Yeah.
My apology.
That's all right.
When it came in, it looked fantastic. This was the drive-in. At this point in time, when you're starting to look at what is actually on that property, you can see that the people that own that property, maintain that property, do not do that in a reasonable manner. So what we look at out of our backyard at this point is a trailer that is actually falling apart, looks disgusting, kind of coming across the board. And this is what is actually sitting on that property. So our concern going forward is with the buffer as far as the property and as far as the 8-foot chain link fence, we're just concerned that it's going to be maintained. So that's a big part of it. The second piece of this, in looking through it, is that within the documentation that we received, what's being requested is the 40-foot property. If I can get some help zooming on this, please. Thank you, sir. Beautiful. Thank you. That's, can anybody see it?
I can see it. Yeah.
Fantastic. So what this is stating is that the 8-foot tall link chain, 8-foot tall chain link fence will be covered with green screening, wind barrier to limit or obscure the view of what's internal. What it does not state on there is that the fencing would also have barbed wire going around it. So from a standpoint of a property owner adjacent to it, the documents that's actually there, their fence details located here, C10, show that there's barbed wire around this. And we would kind of be opposed to that portion of it.
Okay.
Last part of this is, given that the trailer is not being maintained and the property is not being maintained, took a ride just to look at another tower that was actually approved by the board. And when we went out to look at that tower, there was really nothing that was being maintained. So this is another one that's actually on Route 640, east of Route 39. Kind of bugging out here. This is a fence going around the tower, which shows the fencing and then also the 10-foot landscape barrier. If you can see what's actually there, along with the fencing that they have here, which is showing all kinds of mold, and the fence is actually coming apart. And in this particular case, you also have where fence pieces are missing. I'm just concerned about the maintenance of this particular piece. Since this is going into the Summerfield community right there off of Big Bend Road, as an individual looking at this, I'd request that this property be put under the same guidelines as the Summerfield HOA as far as the maintenance of that property, as far as what they require. There are rules and regulations within the community as far as how the property is maintained, what the grass levels can be, what the landscaping be. And it would be reasonable to have an impartial, group of people to be able to look at that and at least maintain it. So when we're looking out of the backyard, and I do abut that and look directly out at it, at least it's not looking like this particular trailer that's been there for the last 7 to 8 years. That's all I had.
All right, thank you so much for your testimony. I appreciate it. If you could please sign in, and you're welcome to submit any documents you'd like into the record. Thank you. Next,
Thank you.
please. Absolutely. Yes, sir. Good afternoon.
Good afternoon. My name is William MacDonald. I live at 12036 Cedarfield Drive. When this first came to our attention, we kind of rallied the troops and said we got to stop this cell tower. But we recognize the reality is South Shore is growing at an unprecedented rate, and there's going to be need for more and more cell coverage. So we gave up on that idea, but really, and I do appreciate the clock tower that they're going to make it look like, certainly beats a regular old cell tower. And while I am concerned about a tower being just a couple hundred feet from my home office that I'm at every day, I realize that, as Mr. Goldberg said, there is definitely an issue with maintenance of the facility. We saw the property that we checked out yesterday, and he mentioned having the HOA enforce maintenance. An HOA can do it, or perhaps this body can in fact codify something that requires not only this but any future towers, because there's going to be more towers coming to the area, I'm sure, and specify what kind of requirement standards are necessary or required by Lennar, Tower Engineering, and LCS, in order to make sure that it doesn't deteriorate from the look of the neighborhood. And as far as the trailer he showed you, I have a clear and unfettered view of that trailer, and it is really shabby. And I picture an 8-foot fence with that green material getting wind blown and into all sorts of shreds and whatever else. And if that happens, there has to be some way that it can be enforced in such a way that that fence looks pleasant, or at least pleasing to look at, not irritating. So the maintenance of that facility is our biggest concern at this point in time, recognizing the realities of where we're at. All right, thank you for your time. I do appreciate it.
I appreciate it. Please sign in. All right, you had one more comment? Yes, sir, I'll allow. Just give us your name before you start.
Perry Goldberg. At the May 9th discussion where the board approved the change to the PD, Tower did make the comment that that particular trailer would be removed from the property, or was intended to be removed. I can't find that in the documents anywhere, but if that's happening as a condition, it would be great to know that that is actually going to be removed from the property.
Understood. Thank you for that. I appreciate it. All right, so we'll close opposition testimony as there's no others to testify, and we'll go back to Development Services. Anything further?
Yeah, our only comment would be with regards to the height of the fence, the PRS that approved by the board referenced an 8-foot height. That's also reflected in our conditions. And so the fence cannot exceed 8 feet in height. And I'd like the applicant to address that on the record. because apparently there was, as to whether or not the height of the fence is going to exceed 8 feet.
All right, and just for my own information, the condition says 8 feet, so where, was there mention that it would be taller than that, the fence?
Well, the graphic that was shown by one of the opponents, at least looking at it on the screen, it looked like the chain link part was 8 feet high, and then that was topped by barbed wire,
Oh, I
which
understand.
exceeds 8 feet in height.
Understood.
And that's not permitted by the PRS nor our conditions of approval, which
Right.
reflect the PRS. So I wish for the applicant to address that.
Okay, all right, thank you. So then we'll go to rebuttal from the applicant. You have 5 minutes. There's a number of things that the gentleman talked about that we can address, starting with the trailer.
Thank you. As we stated at the May hearing, the construction trailer belongs to the property owner. We are a leasee. The construction trailer will be removed prior to construction of our tower.
Would you be amenable to adding that as a condition to this approval?
Yes.
Okay, thank you.
The barbed wire on the top of the fence is an anti-climbing device to keep children out from the tower. It's a safety issue. I do have Jared Jackson virtually. He can answer the question as to how tall that fence is, including the chain link fence.
Yes.
And I would like to find out who owns the tower that Mr. Goldberg presented photographs of. They are not ours. They are not representative of what we're proposing. The fence is not representative. The tower is not representative. So I want to draw to your attention that it is irrelevant to our application.
All right, so before we go to the gentleman that can answer the height question, can you address their concerns about the ongoing maintenance of the fence?
We don't have a fence.
There'll be a chain link fence with green slats. That's a condition of your approval?
Yes, there will be a chain link fence. It will be maintained. T-Mobile maintains its properties.
Okay.
Yes.
All right, then if we could have the question of the height of the fence answered.
Jared, are you there?
Yes, I'm here. Can you hear me?
Yes.
My name is Jared Jackson. I'm at 5906 Breckenridge Parkway, Suite A, Tampa, Florida, 33610. Yes, we currently show a 8-foot tall fence with a 1-foot high barbed wire. If 8 feet is the requirement, we have no issues with knocking that fence down to 7 feet with 1 foot of barbed wire. That shouldn't be an issue, but as our plans currently, it's currently 8 feet tall with a foot of barbed wire.
And let me ask you this, the gentleman also had a concern about the barbed wire as being unsightly from his home. Is that your standard practice to add barbed wire to the top of these fences that surround their towers?
Yes, it is. It's an anti-climbing device.
Yes.
All right. Okay, thank you. And then you have time for rebuttal if you'd like to add anything else.
I think we've covered everything.
All right.
Thank
Well, I
you for your
appreciate
time.
your time and testimony. And with that, we'll close special use 23-0218 and go to the last case.
All right, our last case is item J5, special use application 23-0337. The applicant is Thunder Bay Bar and Grill, and they are requesting a 4 COP alcoholic beverage permit, which requires a separation waiver. Staff report and recommendation will be presented by Tim Lampkin following the applicant's presentation. Planning Commission staff will not be offering comment on this case.
All right, thank you. Is the applicant here? Good afternoon.
Good afternoon. Craig Taraski for the applicant, Thunder Bay Bar and Grill.
Could you give us your address, please?
Sure. 490 First Avenue South, Suite 700, St. Petersburg.
Thank
and I have been sworn.
All right.
So what we're asking for today is a 4 COP. And unless I state otherwise, the documents that I'm displaying are included in the applicant's record. So this is subject property. It's at 4901 West Linebaugh Avenue. The establishment that's the applicant, Thunder Bay Bar and Grill, is suites 8 and 9 on the west end. Yes. The applicant's premises is Suites 8 and 9, also known as Suites 108 and 109 on the west end of the building. The building was originally constructed in 1980, around the same time as the Chadbourne Village residential subdivision to the west and north. There are, here's a photograph looking north at the property. This is the applicant's property, and within this same strip plaza, there's an AB permit for the Quick Stop on the other end, and I think it's the Mattaniah Ethiopian restaurant in the middle. The applicant's premises was formerly known as Zach's Old Time Pub. It was, there was an AB permit for that original construction in 80. The most recent for Zach's was 1982. So there's been a 2 COP in that same property since 82, so for over 40 years. And again, essentially the same timing as the construction and development of Chadbourne Village to the west. Here's a view of the subject property from looking towards the east from the west. Note there are no windows or doors on the west side, and that is the side facing the residential use to the west. Here's a view of the subject property looking south. The applicant's property is the last 2 suites on the end of the building. It's approximately, I think, 38.5 feet wide. As part of the change from the 2 COP to the 4 COP, we have to come through for the new AB permit. We require distance waivers from residential and community uses. For residential, there's 1 residential use within the 200 feet. That's Chadbourne Village. That's to the immediate west. In between the, let's see. This is a good photograph showing that relationship. So the Chadbourne Village subdivision is in this direction to the west. There's an 8-foot-high masonry wall along the western boundary of the subject property, providing mitigation for noise and light and odor and such. While the straight line distance to that residential use is approximately 55 feet, there are no openings in that wall, and the vehicular and pedestrian distance is actually in excess of 1,300 feet if you have to go up Plantation Boulevard to the entrance of that subdivision. Again, there are no pedestrian walkways, there's no openings on that wall. The distance waiver from community uses, we have 2 community uses. We have the Garden of Talents, which is in Suite 2 of that same building, approximately 115 linear feet from the proposed wet zone. The Garden of Talents was established after Zach's Old Time Bar and the Quick Stop. So it came in while there were already 2 AB permitted uses in that building. It also supported the Mattaniah's AB application back in, that application was made in 2018, I think approved in either December, potentially January of 19. I have to enter into the record as new evidence a statement of support from the owner and operator of that Garden of Talents. It states, and this is from Clara Agudelo, it states, "Good afternoon. I'm writing to say that I'm supportive of Thunder Bay and Girls' application for special use and 4 COP alcoholic beverage permit for the establishment at 4901 West Linebaugh Avenue. I have no concerns about conflicts with our after-school and Zumba dance program." And since this is new evidence, I'd like to enter into the record.
Absolutely.
Okay. The other community use within 500 feet is the Play World Academy at 5002 West Linebaugh. That's across Linebaugh Avenue and to the south. And as you can see, even though as a straight line it is 452 feet, the pedestrian and vehicular path to go from Play World Academy to the subject property would be over 800 feet, and it would cross a 4-lane divided highway. So that provides mitigation against any potential conflicts between those two uses. We meet the code's requirements for the not greater than 3 within 1,000 feet of the categorized alcoholic beverage types. I should also note that we're going from a 2 COP to a 4 COP. The 2 COP is considered the same intensity of AB permit within your code. And you've had ZACs operating since 1982, so 41 years at the same location with no documented issues or conflicts with the surrounding uses. As further mitigation, we're in agreement with the conditions, the recommended conditions of approval in the staff report. Those include some hours restrictions on outdoor alcoholic beverage consumption and outdoor music and amplified sound. We are asking to be allowed to have outdoor AB consumption and outdoor amplified music and sound between the hours of 11 a.m. and 10 p.m. Sunday through Thursday, and 11 a.m. to 11 p.m. on Fridays and Saturdays. So what that means is that during the weeknight days, Sunday through Thursday, there will be no outdoor alcoholic beverage consumption or outdoor music or amplified sound after 10 and after 11 on Friday and Saturday evenings. We're agreeable to adding a 6-foot fence on the west side of the rear outdoor area. And as I stated before, there's an existing 8-foot masonry wall on the west boundary of the subject property, which provides additional mitigation. And we're here to answer any questions that you may have.
I just have a couple of questions. Thank
Sure.
you. So I understand you got the letter of support from the Garden of Talents, that childcare facility.
Yes.
The other one, you showed the pedestrian distance being significantly more. Did they also provide you a letter or some kind of testimony?
No.
Support? No. Okay. But didn't express any concerns?
No.
All right.
No.
And then regarding the distance to residential zoning, did you hear back from anyone that was in that notice mail out?
No, we heard nothing.
Okay. And then lastly, the condition which requires the 6-foot high vinyl fence along the west side, is that adjacent to the building? Where will that be?
So here's a view of the rear of the building. It would be so somewhere to not interfere with the tree. And let's see if I could show.
Madam Hearing Master, to jump in if I could.
Yeah, absolutely.
When we got to our turn, I was going to note that in condition 4, we want to insert the word outdoor before wet zoned area. So the 6-foot high fence will be on the west boundary of the outdoor wet zoned area at the rear of the building. And that outdoor wet zoned area extends, I think, about 10 feet.
Yes,
from
it's
the
very
rear of
small.
the building. So, yeah, we will submit a revised report with the word outdoor there, which is consistent with the narrative that talks about, because there's obviously no reason to put a 6-foot high fence where the building is. So it'll be in the back outdoor areas where that 6-foot high fence will go.
Adjacent to just the wet zone portion of that building?
Just the outdoor, the
understood.
rear outdoor wet zoned area is where they have to put a 6-foot high fence on the west side of that.
All right, thank you for that clarification.
Yep.
I appreciate it.
Yep.
All right, that was the end of my questions, unless you had anything else.
I have nothing else.
All right, thank you so much. Then next we'll go to Development Services.
Good afternoon. Tim Lampkin, Development Services. for SU-AB 23-0337. Pursuant to Land Development Code Section 61111, the request, as the applicant stated, is for a distance separation waiver for COP alcoholic beverage permit to allow the sale of beer, wine, and liquor for consumption on and off the permitted premises. The wet zoning is sought for Thunder Bay Bar and Grill, located at 4901 West Lineball Avenue. The wet zone area will comprise 1,925 square feet of indoor area and 621 square feet of outdoor area for a total wet zone area of 2,546 square feet, as shown on the revised wet zone survey. The applicant is requesting a couple distance separations. The first requirement is that the distance from the proposed structure to community uses be 500 feet. The proposal does not comply. And the distance from residential shall be 250. The request does not comply, as the applicant detailed. And there shall be no more than 3 of the same classification, and they're in compliance with that. The applicant requests, as they stated, 2 waivers to the community uses. The first is to allow a 385-foot reduction to the required separation from the Garden of Talents, to allow a separation of 115 feet. And the second is to allow a 48-foot reduction to the required distance separation from the Playworld Academy, to allow a separation of 452 feet from the proposed AB location. And the last is to allow a waiver of 195.3 feet to allow a distance separation from residential from 54.7 feet. The applicant has provided additional justification in their narrative. Staff does find that the proposed wet zoning is separated from the residential by an 8-foot-high masonry wall. And that's shown in Figure 1 of the report. I believe the applicant also showed it. The single-family homes are also approximately 1,600 feet. There is no direct access through that wall. The proposed wet zoning will also replace, as the applicant stated, 2 COP permits that were established in 1980 and 1982, and they were in place before the Garden of Talents Child Care Center, which the applicant just submitted a letter in support today. The proposed wet zoning from the daycare or the from the Playworld Academy is approximately 700 feet if you go by vehicular access, and approximately 900 feet if you utilize the crosswalks. Staff has received no objections to the proposed wet zoning from the residents or the operators of the 2 child care centers. And for the reasons discussed above, staff does find that the proposed wet zoning does not pose significant impacts on the surrounding land uses, and the necessity for the specified distance separation requirements is negated by the circumstances. Staff finds it approvable, subject to recommended conditions. I can read the conditions. They are in the report.
Yeah, it's not necessary, but thank you so much. I appreciate the offer. All right, we will now go to anyone who would like to speak in support. Anyone in favor, either in the room or online? Seeing no one. Anyone in opposition to this request? All right, anyone online in opposition?
Not seeing anyone signed up.
All right, thank you so much. Development Services, anything else before we move on?
No, ma'am.
All right, thank you. Sir, we have 5 minutes for rebuttal if you'd like it. All right, thank you for that. Then we'll close special use AB 23-0337 and adjourn the hearing. Thank you all for your time and testimony.